Welcome to the Dean's Court Chambers lecture series. My name is Patrick Gilmore and I am a family barrister at Dean's Court Chambers. I specialise in public law and private law Children Act cases. Today I want to talk to you about forced marriage and the recent decision of Re K, which is an important decision from the President of the Family Division. Before I do, I would like to summarise, however, some of the basic concepts relating to forced marriage protection orders and some of the common misconceptions. The starting point always has to be, what is forced marriage? I've set out there upon the slides the definition from the FL 701, the application, and also the definition from the President of the Family Division within Re K. From my perspective, the starting point has to be that there is absolutely no excuse for a forced marriage. As the President noted in Re K, it is a fundamental abuse of human rights. Stripping the matter back to the base definition, forced marriage is a marriage that takes place without the full and free consent of both parties involved. The consent and the ability to choose and to say yes or no is a fundamental concept. In a case where you do not have that level of choice and that is taken away from you, this is a case likely involving forced marriage. As the President has outlined in some detail within Re K, that forced marriage can involve both physical force, but it can also involve acts of intimidation and emotional harm that can be equally as damaging, and each of them affect parties long term and can affect them for the rest of their life. As I noted earlier, therefore the key aspect here is consent and the ability to choose. I want to look very briefly at the consequences of forced marriage. As the President has outlined within Re K, forced marriage and the disregard of a person's consent is a form of domestic abuse. And as the President again outlined in Re K, it forms the start of a potentially unending period in the victim's life where much of her daily experience will occur without their consent and against their will. Being subject to forced marriage, as I've said, is and does have both physical consequences and long-term emotional consequences. The President has outlined very clearly within Re K that the consummation of that marriage will be rape with ongoing deprivation of liberty and physical abuse to that person. I want to next address some of the common misconceptions in respect of forced marriage. And the first one is that an arranged marriage is not a forced marriage. I have addressed repeatedly so far in this lecture the concept of consent and the ability to choose. Within an arranged marriage, the person does have that choice. They can say yes or no, and they have the choice if they wish to marry. Within a forced marriage, that has been taken away from them. The second misconception is that forced marriage only impacts upon women. It can equally apply to men, and professionals working to protect those from forced marriage should be mindful that you can have situations where both parties to the marriage have been forced into it. Thirdly, there is an assumption and a common misconception that pressure only comes to those subject to forced marriage from immediate family members. Again, those professionals working with those trying to protect from forced marriage should be mindful that it can be from family, it can be friends, it can be wider community, it can be any individual, and that emotional pressure applied should be considered as part of an assessment. And the final misconception is to assume immediately that one warning marker or one warning sign is an immediate indicator of forced marriage. Professionals are always mindful that there is often only one opportunity to assist somebody and protect them from the risk of forced marriage. However, nothing can substitute a defined and detailed assessment where that professional understands the risk that is present and understands the family they are working with. Therefore, they should not always assume that one sign is an immediate indicator of forced marriage unless they have assessed the matter in more detail. I'd like to address very briefly forced marriage protection orders. As outlined on the slide, forced marriage protection orders can be made under the Family Law Act 1996, and the purpose of those are to protect those at risk of forced marriage, but also to protect those who have already been subjected to a forced marriage. As the President of the Family Division has outlined within REK, the wording of the Family Law Act is very flexible, and it is done so to allow the court to consider the prohibitions and restrictions that they deem are necessary to protect individuals from forced marriage. For my personal view on the matter, when I draft forced marriage protection orders, I like to approach them on a very particular basis, which is that the order should be bespoke to that particular case, but also proportionate to the level of protection required. I'd like to move on and address the purpose of today's lecture, which is to give an update following the recent case of REK. REK, as I have said, is an important case, and I would suggest is essential reading for anyone who is either representing or advising those involved in forced marriage protection order cases, or professionals, frontline professionals, who will be seeking to protect and prevent forced marriage in the future. And that is because the President sets out not only the history of the case law in respect of forced marriage protection orders within the family court, but also sets out in a very summarised and eloquent way the forced marriage in this country and what amounts to a forced marriage. I'd like to very briefly give you the facts of REK. It is an appeal that was heard by the lead judge, who's the President of the Family Division, and that related to Kay, the appellant, who at the time was a 35-year-old single woman. In June 2015, the police applied for and were granted a forced marriage protection order. That stemmed from allegations made by Kay that her family wanted her to marry against her will. The matter came for a final hearing in June 2016, at which point Kay had withdrawn her allegations, and the judge, however, concluded that despite that withdrawal, that Kay still required the protection of a forced marriage protection order. And the judge went on to order that her passport be held by the police and that she was forbidden from applying for a new passport. In essence, the judge provided an open-ended passport order. After a period of time, Kay applied to discharge that order, and the discharge application came before a judge in December 2018, and the discharge was refused. Kay subsequently appealed, and the President of the Division gave the lead judgment. Ultimately, the President concluded that the appeal would be allowed, and the matter was listed in 2022, 2 years later, for a review, that being 4 years after the original discharge application in 2018. The reason that I say the REK judgment is so important is because the judge sets out in detail 4 stages that the court will go through when deciding how and if to make a forced marriage protection order. It's what I call the President's route map to judgment, and I've set them out in the following slides. The first stage of that, which is perhaps the most obvious stage, is stage 1. The court needs to establish the facts on the current evidence in that case. In essence, what is the applicant trying to prove? What facts in this case establish the protection as sought? Here, the burden of proof lies with the applicant on the civil standard. Importantly, however, it is necessary to identify what facts remain contentious at this stage, and it is important to identify from the earliest possibility what facts are contentious and how they are going to be resolved. And as is identified within REK, it may be necessary for the court to resolve any contentious facts, perhaps by way of a fact-finding hearing. Once the court has established that factual matrix, the court can then move on to stage 2. Stage 2, as I've outlined on the slide, is in essence, is there a need to protect a person from one of the 3 following? From being forced into marriage, from an attempt to force them into marriage, or has somebody already been forced into marriage? In essence, is the purpose of the Family Law Act Section 63 established? It is perhaps obvious that stage 1 and establishing the facts in this case will naturally impact upon stage 2 and will help to identify whether or not one of those 3 scenarios arises. Here the court is looking for tangible evidence to help show that this is a case that falls squarely within the Family Law Act 1996. The third stage that the court will then apply is what is known as the balancing exercise. It is here that the court is balancing the risks versus the protective factors. But it is important here to remember that this is not generic risks and it is not generic protection. It is case specific. In essence, what the court are looking to determine is the positives and negatives in respect of this individual case. And within RK, the President of the Family Division stated, "It is important. This is an important stage and the court may be assisted by drawing upon a balance sheet of the positives and negatives within the circumstances of a particular family, insofar as they may relate to the potential for forced marriage." As I've noted on the screen, it is at this point in the analysis that the court is deciding on the facts of this case. Does the balancing pros and cons approach establish a real and immediate risk to that person's Article 3 rights? If the court answers that in the affirmative, they will then go on to consider the fourth stage and the final stage. And that is, if the court are satisfied that the facts on this case demonstrate that Article 3, so namely torture, inhumane or degrading treatment, then the court must reach an accommodation between the protection required and the person's respect for their family and private life. It is very important here that the court is not saying, and the President did not say, that this was a strict balancing exercise. It was reaching an accommodation between the Article 3 rights and the Article 8 rights. The court will obviously be mindful of walking a very fine line between these competing rights, whilst also ensuring the protection of the person who may be at risk of forced marriage. However, again, as I've outlined on the slide for you there, the President is very clear that there is a high degree of flexibility which is afforded to the court by the open wording of the Family Law Act, and in each case the court should be encouraged to establish a bespoke order which pitches the intrusion on private and family life at the point which is necessary in order to meet the duty under Article 3, but no more. In effect, the court are seeking to establish what is the minimum protective measures that can be provided to meet the safety of this person and avoid the immediate risk of forced marriage. I'd like to thank you for listening to this lecture today. RK is an important case to read for anyone who will be involved in forced marriage protection order cases or professionals seeking to protect people from forced marriage in the future, primarily because it is an excellent summary of the forced marriage protection law in the family court, its impact on the victims of forced marriage, but also the flexible and proportionate approach that the court can take in protecting those at risk of forced marriage. Thank you for listening today. Please do listen to the other lectures as prepared by Dean's Court Chambers.